last session for today, which will be the lecture on the influence of common law and civil law traditions in international adjudication and arbitration, given by Judge Joan DONOGHUE. Judge DONOGHUE served as president of the ICJ from 2021 to 2024, and also served as a judge there from 2010 to 2024. She also has wide experience in international arbitration. For many years, she served as an attorney at the U.S. Department of State. With such a distinguished experience through practical work in the field of international law, it is truly an honor for us to invite her to this seminar this time. With that, Judge DONOGHUE, the floor is yours.
Thank you. I hope you can hear me. You've seen that I've moved my position to a different one. Is it audible? Good, thanks. Well, then I'd like to thank the Foreign Ministry, first of all, for inviting me to join in this seminar, and to thank all of you for your interest in international law, your work in the field, and your attendance here in this seminar. You've had from Mr. Reichler an overview of some aspects of international adjudication and arbitration, and you've also had his tip that we should turn off our phones, which I followed. Well, I will say I put it on airplane mode at least, so I hope I won't be the culprit. But I will tell you, although I don't remember his phone going off, I do remember as president twice that judges' phones went off while in the courtroom. So it is a good admonishment. You're going to hear from a range of other lecturers this week, and I know that you'll hear later in the week from someone who will speak about arbitration in particular. My topic goes into a specific issue that arises both in adjudication, such as at the ICJ, and in investor-state arbitration. So it's a little bit more specific of a question. And that topic is the topic of the influence of the common law and civil law traditions on these two forms of dispute settlement, state-to-state adjudication and investor-state arbitration. This could be a very technical topic. And I could cite to you many articles of various rules, but I'm not intending to do that today. My objective instead is to shine a light on the way that the legal tradition in which each one of us was trained impacts the way we approach international adjudication and arbitration, whether as a judge, arbitrator, counsel, scholar, ministry official. So for this reason, I asked the organizers to kindly share with the participants in advance a list of some relevant provisions of legal instruments which you can study at your convenience. And I also asked them to share with you some points for your own reflection as you think about the legal tradition in which you learned to be a lawyer and what that causes you to bring into international adjudication and arbitration. I want to say, since I joined the ICJ in 2010, I've come to appreciate how each person involved in adjudication and arbitration is likely to have ideas about how courts and tribunals should operate that come from the person's individual legal training. And that has led me to explore the preferences that I brought to the court and to understand why colleagues from other legal traditions see things differently. So that has caused me then to deepen my understanding of the origins of the procedures and practices that are used today in adjudication and arbitration, and to try to educate myself about the civil law tradition in particular. So I hope today to share with you some of what I've learned so far. I wanted to mention to you, because I've spent much of the last 6 months or so since I left the court in London, that you might find it helpful when I speak about instincts that we all have to think about what it's like to cross the street in a country where the drivers drive on the opposite side of the street from the side where they drive on where you live. So I come from the United States. I've spent, say, 10 weeks this year in London, where on the UK they drive on the left side of the street. Here in Japan, the same. They drive on the left side of the street. I never look the correct way when I'm getting ready to cross the street as a pedestrian. Many of you, I hope, are better at it than I am. But these things are just so ingrained in us, and what we learned in law school, what we understand about the way to approach adjudication is also ingrained in our professional minds, and I just want to encourage you to keep that in mind. I also want you to think critically about whether there are ways in which the traditions and practices in your own country you think would be enriching of international adjudication, and also the ways in which the practices that take place in your own country don't fit very well with international adjudication and arbitration. Now, in the course of this lecture, which is intended to take 140 minutes, I don't have very much time for questions. I'll stop a couple times and see if there are questions on what I've covered so far, but I would ask you to keep those questions brief. If you have questions, you're welcome to ask them, but we don't have time for long discussions, such as some of those that I heard in Mr. Reichler's session, unfortunately. So first thing I want to start with is something you may be wondering about, which is why is this person talking to us about the influences of the common law and civil law traditions only? After all, she's sitting in a room with lawyers who come largely from Asia and Africa, and many of you come from countries where other legal traditions are applied largely or perhaps in addition to the civil law and common law traditions. To explain why I've done that, I need to take you back to 1899, the year of a peace conference in The Hague, in the Netherlands. And I'll do that with a photograph. So this peace conference, which took place in the Netherlands, was organized at the initiative of Tsar Nicholas II of Russia. And his primary objective in organizing this conference was to curb the military threat that Germany posed to Russia. Who was invited to that peace conference? It turns out the invitees were the states that had diplomatic representation in Russia, and 3 others, 2 European states and Siam, now Thailand. If you look at this photograph, you'll see all of the participants are men, and most of them are either European or of European origin. The 1899 Hague Peace Conference did not achieve some of the key objectives of the Russian Empire. He didn't make any progress, Tsar Nicholas, in arms control, but it did result in a convention on the peaceful adjustment of international differences, and that convention established the institution known as the Permanent Court of Arbitration, not actually a court, but based in The Hague, and one of a couple of institutions that provide exceptionally high quality support to international arbitration, state-to-state, investor-state, and other arbitration. Now, when these gentlemen, largely of continental European or what is sometimes called Anglo-American tradition, when they worked to draw up the procedures that would apply in that new institution, the Permanent Court of Arbitration, where did they get their inspiration? They got it from the procedures in their own national courts. Now, move forward about 20 years, and here's a picture of a group of jurists who were charged with preparing the draft statute of the Permanent Court of Justice. So, although the Hague conferences in 1899 and 1907 did not succeed in establishing a world court, which had been the objective of some participants, there was such a court established in the Covenant of the League of Nations, and that's the Permanent Court of International Justice, the predecessor of the current International Court of Justice. And here you see the people, all men again, who drafted that statute. And again, you're looking at a group of people who appear to be largely European or of European origin. This is just a picture of the members of the Permanent Court of Arbitration, 1924, and you'll see the same point can be made then. Well, the Permanent Court was dissolved when the current World Court, the ICJ, was established in the Charter of the United Nations after World War II. And here's a photo, not just after World War II, but of the members of the International Court of Justice, 1961, still all men. it's getting a little more diverse by 1961, but not very. Why? Because in 1961, as you all know, much of the world was still in colonies. So, but as independent states were established in the ensuing decades, the new states, as they emerged from colonialism, tended to follow entirely or in part the legal traditions of the previous colonial power, sometimes incorporating as well other legal traditions, indigenous traditions, Islamic law, for example. And this map, which is prepared by the World Bank, gives you a bit of a snapshot. It's something of an oversimplification, but I still think it's helpful for you to have in mind for purposes of the topic this afternoon. Blue means that the World Bank is categorizing those states as civil law. Orange means common law, but it looks like there's a fair amount of orange on that screen, but bear in mind that the United States and the parts of Canada other than Quebec are large land masses, as is Australia and as is India. If we actually just looked at a list of those orange countries, there wouldn't be that many of them. And then the gray is something that the World Bank has categorized as other. Sometimes they're truly other. In other situations, they're probably more accurately described as mixed. I think Quebec would be an example of mixed. So, although this isn't a perfect picture, I think it helps to illustrate that as we moved from rules and procedures that were developed in 1899 and through several other successive periods to the present period, we find ourselves in states that a great many of which will associate their legal traditions with either the common law side or the civil law side. One final point on this common law, civil law taxonomy is this. There have been many courts created since the World Court was created the current World Court was created in the UN Charter, and many other kinds of tribunals and institutions have been created. Where do the lawyers who are sitting around in the room trying to decide what should be the procedures for the Law of the Sea Tribunal or investor-state arbitration, where do they get their inspiration? They take the documents that exist in existing instruments and they look at them for templates and they discuss, do these fit here? Should they be changed? If so, how? The only difference is that as we've moved forward in time, the participants, particularly the participating states, now include the full range of states that have come into existence since the ICJ was created, for example, right after World War II. But what that leads us to, in general, is a group of courts and in international arbitral tribunals that in large part owe their heritage, their genetics, if you will, to these very early discussions that took place in The Hague in 1899, in 1907, and then in the preparation of the statutes of the Permanent Court of International Justice, and then the ICJ. So, what are the key features of the common law and civil law traditions, and how do they compare? I want to say at the outset that this is complicated, and it could be, much could be said about it, and it's possible to oversimplify it, and I'm going to do some oversimplification now. You'll hear some things that I'll say, and you'll think, well, that's a little bit of an exaggeration. But I do that in order to create this juxtaposition and allow you to reflect. But before I turn to that, I want to call your attention to the fact that when we think about a national court anywhere, the image that comes into our mind probably looks something like this. So it's a triad. We have national judges and two parties, one complaining party and one responding party. That's a pretty standard triad. But what we have to remember is a national court is only one manifestation of the legal tradition in that state. We can look at various other things to understand that legal tradition. How does the legislature function? There's an executive, presumably. How are lawyers educated? What kind of structure, what kinds of emphasis are placed in their education? How free are people in that state to agree or disagree with the views that are put forward by the government of that state. How are attorneys viewed? What's the status of the legal profession in that state? What about judges? What's their stature? How are they chosen? These are all aspects of a legal tradition of a particular state. And a legal tradition is only one manifestation of a country's broader social, political culture. And what that means, for example, the capacity of courts to overrule actions of a legislature or an executive may exist as a formal matter. And in some cases, there's a question whether courts in practice do intervene to invalidate the acts of a legislature or of a prime minister as exceeding the person's authority. More broadly, what are the cultural expectations for using courts generally? Is there a tendency to take disputes to courts? Certainly that's often a way that the United States is described, or are other means of solving disputes typically given prominence in that state. So, although today I'll be focusing on what happens in a courtroom, in national courtrooms, and in international courts and international tribunals, it's important as we think about what happens inside of this triad always to remind ourselves that what happens there is taking place in a broader context. So now I'll start by reviewing some of the differences between the civil law and common law courts that I'd like to have in mind before we turn to international courts and tribunals. So on this screen, I've got 4 categories that I'm going to cover with you today. First, what are the sources of law that judges apply? In civil law countries, the judges do not make law. They apply law that is made by a legislature or by an executive organ. On the other hand, common law courts do also apply rules in legislation or executive orders, but they also can make law by pronouncing what the law is. And that means that in a common law country, a judicial decision is also a source of law. Second, looking on the upper column on the right, who is directly affected by a court's decision? A decision of a civil law court settles the particular dispute between the parties. This decision is not binding on anyone other than the parties. On the common law side, I've said that common law judges make law, which means that a decision of a common law court binds the parties and creates binding law, can bind also entities that are not parties to the decision. So, for example, when the U.S. Supreme Court decides that the law of one of the 50 U.S. states is invalid, it resolves a dispute in that particular case between a U.S. citizen and that particular state. But it also makes pronouncements that binds everyone in the country. Third, the overall style of proceedings in civil cases is very different. On the civil law side, the proceedings are typically described as inquisitorial, meaning that a judge leads the process of developing the materials that will form the case file. On the other hand, a proceeding in a common law court is typically described as adversarial. It's party-driven. The court has a set of rules that are intended to ensure fairness and equality of the parties, but it's largely left to each party to decide how best to present its case to the court, what legal arguments to present, what evidence to put forward. And in the civil law system, the emphasis is on written proceedings, including written evidence in the form of documents. By contrast, in the common law system, there's much greater use of oral witness testimony. And when there is oral witness testimony, each party is given an opportunity to challenge that evidence given by witnesses, for example, by cross-examining them. And as is often illustrated on television programs about U.S. courts, that cross-examination can often be quite aggressive. And then my fourth point of distinction is that there are enormous differences in the style and logic of written decisions of courts on the civil law side versus the common law side. And here I just want to stop and say that, of course, within the civil law tradition, there is variation. There's no doubt about that. But for international adjudication and arbitration, it's the civil law tradition in France in particular, and to an extent as well, in other states that have adopted approaches from France that dominates. And that goes back to the fact that it was the French tradition that really took hold in the early stages of setting up these institutions. But I would also say that it remains the case that traditions in France are often cited in discussions about international adjudication and arbitration as the ones that are especially relevant on the civil law side. So, how does a civil law decision in the French tradition look? Traditionally, and especially in the highest courts in those countries, it can be a single sentence broken down into a series of clauses. And even if it doesn't follow this one sentence format, it is expected to start with an abstract legal principle. And sometimes the legal principle is stated simply by reciting the text of a code provision. And then there may be a reference to the facts in a particular case. But from the standpoint of a common lawyer like myself, the discussion of the facts that I see in civil law judgments is much briefer and less detailed than one typically sees in a common law decision. And then the result is stated. So recitation of code provisions, brief summary of what the facts are, and then the decision stated in the dispositive operative paragraph, the dispositif in France. And that dispositive paragraph operates as the decision and therefore sits separately from the reasoning that supports it. So the archetypal and maybe stereotypical image of judges is that they're engaging in a task to apply a code to particular facts, and that the conclusion that they reach should flow logically and inevitably. And because it should be seen as flowing inevitably, the outcome is sometimes presented as if it's the only possible outcome of applying a specific code provision to the facts of the case. Now, there's much more one can say about this and more nuance to fill in about the clues that can be used to understand more about what is said in a civil law court. But I'll leave that as it is. And the last point I'll mention on the civil law national court is that traditionally there are no dissenting or separate opinions. If it's a court where that involves more than one judge, the court renders the decision, and the outsiders don't know whether that was unanimous or not. So this style of reasoning can be seen to fit with some of the other characteristics of the civil law system that I mentioned. First, if the job of the judge is to decide a dispute and to bind only the parties of that dispute, then it makes sense that the judge may feel that it's only necessary to set out the rule, summarize the facts, and decide the case, because the decision isn't binding on others, and therefore it may not be seen as important to provide details on why the outcome in this case fit with these facts, but might not fit very well with facts in an earlier case or in circumstances that might come up in the future. I should also say that in certain respects, the structure of judicial reasoning in civil law states has evolved in recent decades. And in France in particular, the two highest bodies, the Cour de Cassation and the Conseil d'État, which traditionally each followed the one-sentence format, in 2018, each of them abandoned that format and moved towards a narrative style, but in each case, they emphasized in so doing that the logic that they see as important, start with the law, describe the facts briefly, move to the dispositif, that must remain unchanged. So now shifting to the decisions of common law courts and how they are structured, what is their reasoning, what's their style of decision, it's very different. And I would say it is more variable than are the decisions in civil law courts. Very typically, courts in the common law, and here I'm speaking of courts of first instance, do not start by citing the legal provisions of interest, but rather by framing the issues in the case. What are the issues in the case? And they frame those issues often in a way that integrates the legal questions that need to be settled and the questions of fact that are in dispute. And they do that often in considerable detail. So when you study a decision in a common law court, you often see that the court first approaches its decision in relation to the specific case, and then after it renders its decision on the specific case, the broader reasoning that could be relevant may emerge from its application of the law to the facts. So with the common law mindset, the thinking is often, I can't really articulate what the general rule is until I've tested various ideas on the general side against specific facts. And once I've done that, then I think I can articulate a general rule. So often in a common law reasoning, the general rule comes out at the end instead of the beginning. And so in that sense, the logic of a traditional civil law approach can be seen to be inverted. And the last difference that I'll mention is that separate and dissenting opinions are allowed in civil law systems and are very common. In the next slide, I've just mentioned a few other aspects of civil law and common law variability that I'm not going to cover today. But I'll just mention, I'll call attention to a couple of things. The first that I mentioned earlier is the variation in the approaches to legal training. Very different in the common law system. The application of law to facts is really the core of the way lawyers are trained. And in the civil law system, quite frequently, the emphasis is on understanding the rules of law, whether in national law or other bodies of law that might be studied. So far, I've talked about the origins of adjudication and arbitration in the civil law and common law tradition, where they started and why they persist today. And I've given you a very skeletal overview of the key differences in national courts that I think find their way into some of the questions that arise today in international adjudication and arbitration. And now I'd like to turn to international courts and tribunals. I don't have time to take a lot of questions, but if there are any specific points that on what I've discussed so far that any of you wish to raise, please let me know and by putting your hand up. Good, then thanks. I'll move on. And here I've got a slide that mentions some institutions and instruments, just to give you a frame of reference. And in the left-hand column, I've listed some institutions that are involved in settling state-to-state disputes, the ICJ, of course, the International Tribunal of the Law of the Sea, which Mr. Reichler mentioned earlier, and the Permanent Court of Arbitration does also get involved in settling state-to-state disputes. Of course, there are many regional courts of various sorts as well. In the middle column, I've mentioned two institutions that are associated with investor-state arbitration. ICSID, the International Center for the Settlement of Investment Disputes, that's a center that supports arbitral tribunals, and the Permanent Court of Arbitration, also not a court, but provides support. Both of those institutions provide excellent institutional support to arbitral tribunals of various sorts, including those engaged in investor-state arbitration. And then in the right-hand column is something a little different. These are not institutions. These are rules that you hear about often when talking about arbitration in particular. The ICJ has its own set of rules and statutes. That's one complete body. But when we shift to arbitration, it gets more complicated because each tribunal decides with input from the parties what rules it will apply. Frequently, investor-state arbitration is governed by arbitration rules promulgated by UNCITRAL. if the arbitration is an arbitration that arises under the ICSID convention, then the ICSID rules apply. And then you'll see there that I've referred to the International Bar Association rules on the taking of evidence. Those are rules that are regularly incorporated into the framing of the procedures to be followed in international arbitration, whether those arbitrations are taking place under UNCITRAL rules or under ICSID rules, because they address issues on the taking of evidence that are not addressed in the other rules. So on this slide, I want to just take a minute to walk you through typical stages in international adjudication and arbitration. I wasn't here this morning, so it's possible that Mr. Reichler covered some of this. There's a lot of variation, for sure, but there's enough similarity in the way that proceedings move forward in international adjudication and arbitration that I thought it might be helpful to review that. First, a case is initiated, and most typically the case is initiated when one state brings a case against another, or in arbitration, when an investor brings a case against a state. And just for today, I'm focusing on what happens in the main case on the merits. So after a case is filed, there's a pre-hearing phase, and all kinds of things might happen in that phase other than a focus on the merits. There might be a request for provisional measures, as has happened very often recently in the International Court of Justice. There may be objections to jurisdiction. There may be requests to intervene, for example. Those are incidental proceedings, and I'm putting those aside. But I want to focus on what happens in the main merits proceedings in a case. And those proceedings typically follow the format that Mr. Reichler referred to: a written phase, usually 2 rounds of written pleadings, followed by oral proceedings, again, usually 2 rounds of oral proceedings. And then after the oral proceedings, the deliberations take place in private, whether that's a court or an arbitral tribunal. And then after the decision is rendered, after the deliberations, then the court or tribunal delivers a written decision. In the case of the ICJ, that decision is read out orally. In the case of arbitration, it's delivered in writing to the parties. Now, I'm going to say more about the ICJ and then more briefly about arbitration. But before I turn to those specifics, I want to go back again to this idea that when we talk about the procedures that take place inside of a court or tribunal, we need to think about the fact that, once again, we have a triad, and once again, to understand that triad, we have to think about the context in which it's operating. So when I talked about national courts, I said that the judicial triad has to be appreciated within the broader social, political, and legal culture of the country. But now I'm talking to you about international courts and tribunals. So how do we know whether the particular procedures and practices are suitable for an international court? Where's the context? Where does that come from? So once again, I've got the triad here. Looks very similar: complaining party, respondent state, and adjudicators. How do we know what the context is? We need to look at why was this form of international dispute settlement created? What are its purposes and functions? That's the context that created it, and then we need to ask ourselves, what happens after the adjudicators conclude their work? How is the decision given effect? So I just want to remind you, when you're looking at these courts and tribunals, to recognize that they have to be appreciated in a context, not just in a sealed-off triad. So now I'll turn to make some comments on the ICJ in particular, focusing first on the context there. What is the purpose, what is the function of ICJ dispute settlement? So once we have those purposes in mind, then I'll say a bit about the sources of law in the ICJ, who's bound and affected by ICJ judgments, some aspects of procedure, and the style of reasoning and decision. Now, I want to emphasize here that in this effort to describe how the common law and civil law traditions influence international courts and tribunals, I am focusing on the role of the ICJ in deciding contentious cases. Those are cases between two states. I'm not speaking specifically about advisory opinions. The function and purpose of the advisory opinion role assigned to the court is something different. Certain of the procedures are similar, and you could see that as counsel, Mr. Reichler thought that certain of the points that he would endorse as counsel would apply in both cases. But the ICJ was given two specific functions in the UN Charter: to decide disputes between states in the procedures known as contentious cases, and to render advisory opinions at the request of another UN organ. But for today's purposes, I'm focusing on those state-to-state cases. It's also widely accepted that the ICJ was given two implicit functions. And the first of those is to contribute to the development of international law. There's a debate in pretty much every case involving scholars about whether the court went too far in developing international law or failed to go far enough. But it certainly was given some scope to develop international law. And in addition, it is expected to influence the behavior of states that are not parties to a particular case by making pronouncements on the law and maybe the facts that will be seen as authoritative not only by the parties to the case, but by others in the international community. So what that means, what these implicit functions mean, is that the decisions of the International Court of Justice must communicate effectively not only to the parties, but also to others in the international community. Now, when I speak about the ICJ today, I want to remind you of something that is easy to lose sight of, which is that the ICJ is peculiar in that it is a court of last instance, meaning that there's no appeal from the ICJ, but it's also a court of first instance. It's a court of first instance like the first instance court in all of your countries. It has to decide facts. It's not an appellate court that's reviewing facts decided somewhere else. And that means that we are going to spend a fair amount of time today talking about evidence, and it's also why Mr. Reichler spent time today talking about evidence, because this court, a court of 15 judges, sometimes 17 judges, has to decide difficult questions of evidence. So now, what are the sources of law that are applied by the ICJ? Well, the ICJ statute, Article 38, famously sets out the sources of law available to the court, and the two sources of law that are given greatest prominence are treaties and customary international law. If you think about this, treaties, customary international law, they seem more like common law sources or civil law sources. They don't fall on either side. So they don't really give us any clue about whether we should think of the ICJ as leaning more towards the common law side or more towards the civil law side. However, the statute also says something about whether judicial decisions are a source of law, because it says in Article 59 that a decision of the court has no binding force except between the parties and in respect to a particular case. So that sounds very much like what we see in the civil law tradition, and means that the ICJ looks quite a bit like a civil law court, because it cannot bind any state other than the state that's a party to the case, and only in relation to that particular case. But we can also see that some ideas from the common law tradition also found their way into the ICJ statute, because the statute says that subject to Article 59, judicial decisions are a subsidiary means for determining the rules of law. So the court is free to invoke its own jurisprudence and that of other courts, national or international, in setting out its understanding of the law. And it derives that understanding of the law by looking at the sources of law that are found primarily in customary international law and in treaties. So we can see that the court stands somewhere in between a civil law court and a common law court in sources of law, although the importance of Article 59, which says that judgments of the court bind only the state's parties and only in respect of the particular dispute, can't be understated. So there's quite a lean towards the civil law side in that regard. And as you can imagine, this was one of many points that was intensely debated from 1899 to 1920 to the drafting of the ICJ statute. Next, let's talk about, I've already talked about who's bound, but who's affected by an ICJ judgment? Well, only the parties are bound, but if we go back to the implicit functions of the court that I mentioned earlier, to develop the law and to influence the decisions of states that are not parties to the case, then we have to recognize that for ICJ decisions to perform that function, they have to be publicly available, and they are. ICJ judgments, its orders are publicly available, as are its written and oral proceedings. And the ICJ has to communicate its decisions and the reasons for those decisions in a manner that informs not only the parties who are interested in the particular disputes, but those in the broader international community who may not be bound by the decision, but who can be expected to be influenced by it. Sometimes those non-parties are not terribly interested in the specific facts of the case, but are quite interested in aspects of the court's reasoning or the procedures that the court follows. So now let's shift to some aspects of the court's procedure. We've talked about the written and oral proceedings briefly, and Mr. Reichler addressed those as well. First, I want to say that the overall infrastructure of the ICJ statute, like that of the Permanent Court of Arbitration, presents only a very general procedural framework. Most of the details that govern the court's procedure exist in rules that were drafted by the court itself and are occasionally revised, or in other instruments, sometimes in orders specific to a case. And those procedures and practices are developed in the court's jurisprudence. As Mr. Reichler said, on certain issues, to understand the way the court is going to approach it, it's necessary to look carefully at the court's jurisprudence. So I'll mention a few aspects of procedure where we see these competing influences of the civil law and common law traditions all the time. So I've mentioned the written phase, usually in two phases. The court's rules require parties to append to their written pleadings the relevant documents in support of their case. And here you can see that in one way, the ICJ operates a bit like a common law court, in that it's up to the parties to decide what evidence they wish to invoke, what law they wish to put into play. So this is not a situation in which a judge is assembling a case file, as we would see in an inquisitorial civil law approach. On the other hand, viewed from a common law tradition, the requirement of submitting all evidence in the written proceedings seems odd. And that's because in national courts following a common law tradition, much of the key evidence is not presented until the hearing in the form of live witness testimony. And even documents to be introduced in evidence need to be authenticated, often by a live witness. So this requirement of submitting documents in advance attached to the pleadings is unusual or a little puzzling to someone coming from the common law side. And it does seem to suggest, might suggest to you, that maybe the court prefers documentary evidence over live witness testimony. Well, if we look at the court's statute and rules, both documentary evidence and witness testimony is available. And there's no hierarchy suggested in the statute, in the rules. But if we look at its judgments, they line up well with practice in civil law states. The court has stated its preference for documentary evidence over witness testimony. It doesn't mean that there are no witnesses, but fact witnesses in the ICJ are not terribly common. And we can see that parties appearing before the court tend to lean in the direction of relying on documentary evidence. In practice, I should say, there are many ICJ cases where it wouldn't make any sense to put witnesses forward. For example, if the court is trying to decide sovereignty over an island or a land territory, and it's doing so on the basis of dueling contentions about 19th century maps. There isn't going to be a witness who drafted that map in the 19th century who's going to appear before the court. So documentary evidence in quite a number of cases is the only relevant case evidence. But even in situations where one might think that a witness could contribute, often the parties don't put them forward. Now, when a party does see fit to place witness evidence into the case, the practice that has developed in hearings lies somewhere between the traditions of the civil law and common law systems. And what I mean is this, that if there's a witness to be presented by a party, the party submits a written, signed statement of the witness, and often that witness never appears in the proceedings. The statement just sits there on its own, especially if the opposing party does not wish to cross-examine the witness. So there's no phase in which either the other party or the judges question the witness. But if the witness does appear, the witness does not start by telling his or her own story, as would happen in a common law court where we would have direct examination of the witness. Instead, the written statement stands as the witness's evidence, and then the opposing counsel and the judges on the bench have an opportunity to question the witness. So, although in theory this questioning by opposing counsel and then by judges could operate much like a cross-examination in a common law court, in practice it doesn't look very much like that. One doesn't typically see the kind of aggressive questioning from opposing counsel that one might see in a common law court, and certainly not from the judges. And one reason I suspect is that counsel, even those from the common law tradition, realize that civil law judges are very uncomfortable with the combative style of cross-examination that one sees in U.S. courts. In fact, they're frequently, it's been widely stated by many persons associated with the civil law tradition who've been involved in adjudication that they don't see very much merit in witness testimony at all. And they really don't like it when witnesses who are on the stand are cross-examined aggressively. That's especially true, of course, in cases where serious violations of human rights are alleged. And I mention that in particular because the court has had those cases on its docket and has those cases on its docket side. Now, you can think about cases in which genocide is alleged, the question whether acts of genocide occurred and whether a state is responsible for those acts of genocide is at issue in important cases, at least one of which, the case brought by the Gambia against Myanmar, is moving towards the merits stage. So why is that so difficult? Well, because cross-examination is an attempt by opposing counsel to discredit the testimony of a witness, either by casting doubt on whether the witness is telling the truth, or by establishing that even if the witness is telling the truth, the witness doesn't have firsthand knowledge of the facts about which the witness testified. If you look in particular at some of the examination of witnesses in a genocide case that Croatia brought against Serbia, you can see how difficult this is. And if you're very curious about this, you might take a look at the oral proceedings on March 5th of 2014, which you can find on the ICJ's website, where a witness was put forward by Croatia. And she was a woman who clearly had suffered greatly. She was in a village that had been destroyed. And she was put forward for the purpose, we the judges knew, that the reason that she was being put forward was that Croatia wanted to establish that the people who destroyed the village were Serbs, and then ultimately later to establish that Serbia, the state, was responsible for those killings. But the witness, who was very emotional, had a great difficulty sticking to the topic. The counsel who cross-examined her had difficulty, and so the counsel for Croatia had an opportunity to come back and try to move her closer to the points that Croatia wanted her to make. And one reason you might find it interesting to look at this is that counsel for Croatia was Sir Keir Starmer, who more recently became the Prime Minister of the UK. But apart from that, it's interesting to see how difficult it was. In the case of that witness, 2 judges from the common law tradition asked her questions very politely and respectfully that I think came closer to getting her to address the points that really the court cared about, which helped us to understand that she didn't actually know about certain of the points that were at issue in the case. So cross-examination can serve as a means for the court to assess the credibility and reliability of evidence, but that's not typically what the court focuses on when it's trying to address evidence. And of course, if the evidence is documentary evidence, then it's not using questioning of a witness in any event. It uses what I sometimes refer to as second-order indicators to evaluate the evidence. And some of these are points that Mr. Reichler raised this afternoon. These are ways to try to assess the quality of the evidence without causing the court to say that a party is lying to it, for example. And for example, a court treats with caution reports that appear to have been specially prepared by the case. There's a difference in the view of the court between a slide or a document that explains what the party is putting forward. So Mr. Reichler's slide that shows what his client considers to be the places where various incidents occurred in the Caribbean Sea, that is that party's effort to consolidate its efforts and to present a nice picture to the court, but that's different from concrete evidence of a particular event because it is prepared for the court, for the hearing. And so we will look behind that kind of evidence and ask ourselves whether we can be confident in it. The court gives much greater weight to statements prepared soon after an event rather than years later. And this can be difficult for counsel who are bringing a case to the court about events that took place a long time ago. The court does not favor secondhand evidence, the kind of evidence typically known as hearsay evidence. It's surprising to me at times how often the court is presented with what is put forward as evidence, but that's really something that the court understands as a widely held view about a particular event. And the court attaches particular weight to evidence that a party introduces that's adverse to the party's case. So Mr. Reichler gave you an example of that. In the case he referred to, where Nicaragua was alleging that Colombia, through its enforcement vessels, was violating Nicaragua's rights under a decision the court had rendered earlier. Nicaragua was very fortunate that tapes of Colombia's own vessel supported Nicaragua's case. So we had evidence put into the record by Colombia that undermined Colombia's own case, and the court will give weight to that. I'll also say that in the same case that was mentioned, there were other incidents that Nicaragua relied on where the court was not convinced by what Nicaragua put forward, looking again at these same kinds of indicators. The court said that in certain cases there was a lack of first-hand evidence, or that the evidence before it was, in the court's view, evidence that was prepared for the hearing and thus not seen as very convincing by the court. Now, I'm going to turn now to say a bit about expert evidence. So I've been talking a bit about witnesses, fact witnesses, but what about expert evidence? Expert evidence, this is a topic where there's a very sharp divide between the approaches taken in civil law courts and in common law courts on the national level, and this arises often as a point of controversy in international adjudication and arbitration. In the common law, in line with the adversarial style of proceedings, if there's expert testimony on a question of scientific or technical nature or the valuation of investments, for example, in the common law, the parties submit expert reports. In the civil law system, a national court appoints its own experts. Under the court statute and rules, the parties have the option of appointing experts, and the court has the option of appointing experts. Many of you the Japanese participants in particular, are likely familiar with the whaling case that was brought by Australia against Japan. In that case, each of the parties submitted one or more expert reports, and then those experts were questioned in court both by opposing counsel and by some of the judges. And the court did not appoint its own experts. The court's judgment, you can see, does place some reliance on what the experts had to say. And it notes in particular places where the experts agreed with each other or where an expert cast doubts on assertions by the party that appointed that expert. Well, the court has tended not to appoint its own experts, but it has done so in a couple of cases recently. In a case brought by Costa Rica against Nicaragua, the court arranged for expert opinion on the state of a specific portion of the coast. What did it look like? What was its, how could the court understand it? As part, what was relevant to the establishment of the maritime boundary, and the court actually sent those experts to the area to look at it. And in a more recent case, a case in which the court had to assess the compensation owed by the Democratic Republic of Congo to Uganda for injuries to injuries to the Congo during armed conflict. The parties had appointed experts, but the court also appointed 4 experts on different topics to assist with the assessment of compensation. Those 2 cases are recent and unusual in that the court appointed experts there. I think in each of those cases there were particular reasons why, in my individual opinion, it was appropriate for the court to appoint experts. But just to remind you of how I am confined by my own common law roots, I would say that I saw specific reasons here. But in general, I'm not convinced that the court should appoint experts in cases involving scientific and technical evidence. And that's because I come from a tradition that's adversarial. So the way that I look at a party's case is that a party has to convince me of its views of the law and of the facts, including the technically complicated scientific valuation, technical facts, if that's what they are. It has to convince me of them in a way that I, as a judge, can understand. And it also has to convince me of it in a way that I, as a judge, can then put into a decision of the court that's available and understandable to the audiences who are reasoning it. So to me, that's exactly the same as the task that I face as a judge if I'm trying to decide a more straightforward question of facts, looking at competing maps from the 19th century or a series of diplomatic exchanges to try to decide what the parties agreed to, the kinds of issues that are very familiar to courts. I will say that when the question whether to appoint experts arises in a case, this is one of the issues where I see the divide between civil law trained judges and common law trained judges come up most frequently. I think this is not only because of the way that our respective courts approach the issue at home. I think it also has to do with the ways in which law is taught and studied in our two traditions, and I mentioned that a little bit earlier. In the common law tradition, we are accustomed to appreciating the law by applying it to facts, and that's essentially what students do in law school for 3 years. Law is made and developed by applying rules and testing possible rules against factual situations. It's my understanding, however, that in many law schools outside of the common law tradition, and many of you will know much more about this than I do, the emphasis is more on learning the law itself, the rules and the principles, with less attention to applying the law to facts. And in this regard, I make a plug for moot courts. And I know that there's the Asia Cup moot court going underway right now. I can't tell you the number of young lawyers who've come through the ICJ who have told me of the way that their participation in a moot court integrated their ability to take the law as they learned it and apply it to the facts. And especially I hear that from young lawyers who are seeking to develop their skills, who come from the civil law tradition. So I really endorse moot courts and encourage all of you to steer the young lawyers whose ability you can influence to participate in moot courts. So now I've said a bit about evidence, and now I'm going to turn to the ICJ's style and reasoning and try to talk a bit more about the extent to which it fits with a common law or civil law style. Let's go back to what I said about the functions of the court, and just recall that the court has two audiences, in essence, the parties. And for the parties, what we're talking about here is the court's core dispute settlement function. The court, when it delivers a decision on the merits, is settling that dispute on the merits. The parties care especially, but not exclusively, about who wins and who loses the case. Non-parties, by contrast, may care more about the general conclusions and the reasoning. For both audiences, it's important for the reader to look at the decision and say, I can understand the result, I can follow the reasoning that led to that result, even if I don't agree with it. But the frequent challenge in collective drafting, in my opinion, is that even when a group of judges agree on the outcome with a particular point, they often disagree on the reasoning that will best support it. They often disagree about what reasoning will be most convincing to show the parties that, and the outside world why this result was the correct one. So as to the structure and overall logic of ICJ judgments, the civil law approach prevails in a number of important respects. Most importantly, I think, in an ICJ judgment, there is a sharp divide between the decision itself, which comes at the very end of the judgment in the operative paragraph, and the reasoning that leads the court to that decision. And that, in my opinion, is a vast improvement over the way that decisions of common law courts are often structured. What I mean by that is that in common law decisions, certainly in the United States, it can be actually quite difficult to identify precisely what was the decision of the court. Now, if it's an appellate court, it will say whether the court is reversing or affirming what happened below. But if you look at the substance of a decision, it's often difficult to tell what was the decision concretely and what were points that the court made leading up to the decision, or what were points that the court made which would be considered dicta, views that the court put forward but that aren't strictly necessary. So personally, I think if the goal is to be clear about what the court decided, I'm all for the court having adopted a civil law approach with a very clear and distinct dispositive paragraph. But ICJ judgments are very different from civil law decisions in their length. They are long. They are not at all like what one sees in civil law courts. On the other hand, they look more like civil law courts in terms of the overall framing. And what I mean by that is that the court prefers to address general principles of law, the law generally, in isolation from the facts, and then to refer to the facts before moving to the final dispositive paragraph. One more point about structure is that, as in common law courts, but unlike in civil law courts, the names of the judges in majority are identified, and judges of the ICJ are permitted to write separate or dissenting opinions. A little bit more about the substance of the reasoning in ICJ courts. I'll go back to what I talked about earlier on sources of law and on evidence. Sources of law, ICJ judgments refer, of course, to treaties and customary international law as sources of law, but you will not find the ICJ referring to its prior judgments as a source of law. You'll never see the ICJ referring to its prior decisions as precedents, as a common law court might do. However, the court has stated in its jurisprudence that it favors a consistent jurisprudence and has said that it will not depart from prior prior findings unless it finds a particular reason to do so. So you can see there that the court is walking a line a bit. When it comes to what the court has to say about the evidence in a case, I'll mention something on the standard of proof, which was a point that I heard discussed earlier this afternoon. Because here again we have a difference between the civil law and common law traditions. In a common law court, a court typically articulates the standard of proof that it's applying in a civil case. In a civil case, in a common law system, the standard of proof is typically described as a balance of probabilities. The parties are arguing about whether something happened, and the question for the court is it more probable than not that something happened? So balance of probabilities. In the civil case, in the civil law system, there's no comparable practice of specifying and articulating a standard of proof. Instead, the question for a judge is whether the evidence satisfies the judge's intimate conviction. Well, the ICJ has generally declined to specify a standard of proof that it applies. And so, in general, it can be said that if one studies the court's judgments, the most one can say is that the court is assessing the evidence based on the subjective appreciation of the judges, as in the civil law tradition. The court's failure to articulate the standard of proof that it's applying in particular cases has bothered some judges from the common law tradition, and in a number of cases, judges from the common law tradition have written separately to complain about that and to say that the court should specify the standard of proof that is being applied. On the other hand, some observers, especially from the civil law side, but not exclusively, have said, well, this doesn't really seem that important because if we look in practice, we think the court is probably normally applying a balance of probabilities standard, more probable than not, except when it specifically articulates a different standard. And it has set out different standards of proof in certain situations. For example, and most importantly, in the case of genocide, it has said that it requires proof at a high level of certainty. So it's articulated a very specific standard of proof. Speaking for myself, I would say when I first became attentive to this issue, when I was involved earlier in my time in the court, in arguments within the court about whether we should refer to a standard of proof, my reactions were kind of twofold. One, why not? What's the big deal about setting out that we're following a balance of probabilities? But also I've come to appreciate that it probably doesn't make that much of a difference in practice. That I think when the judges are looking at a case and they're not setting out a specific standard of proof in the judgment, it most likely means that they're looking at a balance of probability standard. Personally, I would prefer that the court would just say that, but I'm not as bothered about it as some other judges from the common law tradition have been. Now, let me just say a few things about the style and function of style and reasoning used in the ICJ in light of the functions of the court. So the court has a dispute settlement function, explicit function, and to do that, the goal is to communicate effectively to the parties. On the positive side, as I've mentioned, I think it's appropriate that the court sets out the party positions clearly. This is a point that is not typically done in U.S. courts, where the court tends more to summarize the arguments on one side or the other of an issue. But in the ICJ, the positions by the parties are set out separately and clearly. I think it's very important, especially that a party that loses on a point can look at the judgment and say, well, we didn't win on that point, but we know that the court understood it. I think it's very important that the court separates the dispositif from the reasoning so that the parties understand what they won and what they lost. I have less clarity in my mind about the importance or not of separate and dissenting opinions in respect of the dispute settlement function. The decision binds the parties one way or another, regardless of whether there are dissents. I think that the separate and dissenting opinions may serve a function, though, of helping in conversations within the parties, especially the party that's ordered to do something, helping them shape an appreciation of why this outcome was taken by the court and what it suggests about what needs to happen next. Looking at the implicit functions, the functions of authoritative pronouncements and the development of law, I think that the key there is that the reasoning of the court be clear. And as I mentioned earlier, often there are complaints that the court has not taken up an opportunity to elaborate its views on a particular point of law, or someone else is arguing that it went beyond what was necessary to pronounce on a point of law. But when it does choose to pronounce on a point of law that it needs to pronounce on in order to settle the case, I do think it's important, speaking of its broader role, for that reasoning to be clear, particularly on points of law. I also think that the drafting of ICJ judgments has to be evaluated with reference to the role of the court in the international community. It's helpful to know that Mr. Reichler, and he says other counsel as well, view the court with respect. I'm obviously, as a former judge, glad to hear that. But as a judge and as someone very worried about the future of the world, I don't take for granted at all that the ICJ will continue to be busy, that its judgments will continue to be viewed as authoritative. The world is fragile, and there's a lot going on right now. So I believe that in every case, the court has to do its best to perform its function in a way that takes into account the fact that many states have avoided ICJ jurisdiction entirely, and some of them have never appeared before it, at least in a contentious case. We also know that states that lose cases before the ICJ look for ways to criticize the court. So the court must be constantly attentive to the ways in which its procedures and the presentation of its decisions will be unassailable, will add to the court's legitimacy and authority and the way that it's perceived of by states. And this is not always a consideration that's easy to fit with the resolution of a specific dispute. I think it's an essential one. Now I'm going to turn to investor-state dispute settlement, but I'm going to do that more briefly than I did with the ICJ. The one thing that's difficult about talking about investor-state arbitration as compared to the ICJ is that there's one ICJ, it has a statute, it has rules, it has a jurisprudence. But when we shift to investor-state arbitration, we have more than 1,000 investment treaties, and they're not all identical, and most of them are bilateral. We have many, many awards that have been issued, and we have a variety of different sets of rules and institutions involved. So it's harder to generalize, but I'm still going to attempt to do that. And as with the ICJ, I'm going to start by inviting you to think about what's the purpose, what's the function of investor-state dispute settlement. So going back to the beginning, why do we have investor-state dispute settlement? The idea was very much the idea of capital exporting countries, Western developing countries. And those states, along with their companies and nationals, voiced the concern that foreign investors could not get a fair hearing in national courts in the states where they were investing. The proponents said that they sought neutral mechanisms to settle disputes between a foreign investor and the host state. And they took the position that these mechanisms would increase investor confidence in doing business in developing states in particular, and that would add to the flows of capital into those states by allowing them to attract investment. So when the idea was put forward, it was portrayed as beneficial both to states seeking to attract investment and to foreign investors. And as I mentioned, there are more than 1,000 treaties that follow this model, so that idea has certainly taken hold. At the same time, what I'm not going to discuss today are the many discussions that have been taking place in recent decades as investor-state dispute settlement has progressed about ways in which the system needs to be improved. Most significantly, I think, the treaties themselves have been revised to lead to more balanced substantive provisions. I'll speak about the United States in particular. When the United States first began pursuing bilateral investment treaties, it was primarily focused on protecting U.S. investors investing elsewhere. But then when the North American Free Trade Agreement, the NAFTA, came into play, this was a treaty involving three parties, the United States, Mexico, and Canada, and it involved investment going in all three directions. And so what that meant is that the United States began to be a respondent in cases brought by Mexican investors or Canadian investors, and that was valuable, I think, because it led to a recalibration of substantive provisions when the United States began to appreciate that it would not only be a treaty that would be used by its investors, but would also be used against the United States. And more generally, there has been balance in more recent treaties to provide greater scope, for example, for regulation. But I'm not going to talk more about that. I will also say there's been a lot of discussion about ways that arbitral tribunals might be constituted that are different from the ways that have been addressed now. One other point about the context of investor-state dispute settlement that's very important and that distinguishes it from the context of the ICJ is that there normally is some form of review of investor-state awards. So I said that the ICJ is a court of first instance and last instance, but although there's no appeal from an award of an investor-state arbitral tribunal, there are certain mechanisms that are very limited in scope that allow the review of awards, sometimes in a national court and sometimes in a specific process. In the case of ICSID awards, known as annulment, another tribunal reviews a case but in limited aspects. So I'll just say a bit about some of the aspects of investor-state arbitration that tie back to what I've said earlier about the civil law, common law distinction. As to the sources of law, the source of law in a particular case is specified in the governing treaty, and most commonly, the source of law that's specified is the treaty itself. Prior arbitral awards are not sources of law. So in that sense, investor-state dispute settlement looks like the ICJ or looks like a civil law court. But a more subtle point, and this is difficult, I think, is the question whether arbitral awards do have an effect on entities that were not parties to the case. I think what we can say is that they were not designed to do so. And the reason I say that is that investor-state dispute settlement has some of its origins in these Hague conferences that I mentioned earlier that set up the Permanent Court of Arbitration to decide state-to-state disputes in arbitration. But it also has origins in commercial arbitration. So commercial arbitration is a situation in which two commercial entities enter into arbitration outside of a national court to settle their dispute. And in commercial arbitration, the decision to be rendered by the arbitral tribunal is traditionally one that's kept confidential, that's private. If a decision of an arbitral tribunal is confidential, private, then it certainly can't operate to serve as an authority, informally or not, or in another arbitration because no one has access to it. So when investor-state arbitration was first being developed, this model that came from the commercial side was the one that was adopted, so that in general, investor-state awards were not publicly available. This has changed over time for a number of reasons. First, as these awards have come forward, it's become clearer and clearer that whereas a commercial dispute may truly involve the interests of only two companies, a dispute about what a state is doing in its own territory to its own population is likely to be of great interest to that population. So leaving them outside of it, unable to know about what happened in it, was troublesome. And in addition, even though there may be more than 1,000 separate investment treaties, the topics addressed in those various treaties are similar. The precise wording is sometimes identical. And so the parties, when they argue their cases to a tribunal, if they have access to awards that are publicly available or that have trickled out into the public arena, they like to draw on those. And so when the parties are filing briefs that cite these cases decided elsewhere, the tribunals respond by addressing those. So we have a situation in which there's a growing preference for the investor state awards to be made public, and the applicable rules, generally speaking, have been made more flexible. And we see with considerable frequency that there is citation of those earlier awards. This is a point that I think has been criticized by some commentators, and I think with some reason. And one point to mention here is that in arbitration at the ICJ, the costs of the court itself are paid out of the United Nations budget. The parties have to pay their teams, organize their own proceedings, but the court itself isn't paid for by the parties, it's paid for by the UN. In arbitration, on the other hand, the cost of the tribunal is borne by the parties. And so the more detailed and more elaborate the issues that the arbitration tribunal is seized with, the more time and expense goes into analyzing those issues, and the longer the awards get. So that's been subject to criticism on cost side, but also because in an investor state case, if the court is deciding a specific fact situation under one bilateral treaty, in order to settle a dispute between those two parties, there is a serious question about whether it's necessary to go into as much detail as is sometimes done to review prior awards. I think that one consideration that may be in play here, although this is just a speculation on my part, is that the arbitrators want to make sure that everyone who reads the award understands that those particular arbitrators, collectively and individually, did take into account the arguments of the parties that were made on these in relation to these other awards, and did give them weight and reach its own conclusions on them, as opposed to simply ignoring them. A couple of points of procedure that I'll mention that don't feature in ICJ proceedings and that have times been controversial in investor state proceedings, and these are points that focus on evidence, because commentators on investor state arbitration regularly say that the questions related to evidence are among the most difficult in investor state arbitration, especially because of the differences between the civil law and common law traditions. And this is the topic known on the common law side, especially in the United States, as discovery. So in the United States, before a hearing is held, the parties engage in an extensive exchange of information out of sight of the court. And as practiced in the United States, discovery means that, with some exceptions, a party is expected to turn over to the other party all relevant evidence, including evidence that's unfavorable to the party holding that evidence. That means that by the time the court is seized with the case, the court can feel confident that if there's something out there that a party has in its files that's unfavorable to that party, the court will know about it. So think, for example, of a case in which it's claimed that a company knew that a chemical that it was selling possessed health risks. If its internal scientists wrote a memo saying internally that there were those risks, the party will normally have to reveal that memo to the other party in discovery. In the civil law tradition, instead of this exchange organized between the parties, it's the court that might ask a party to provide to the court any documents that the court thinks are necessary that haven't been provided. Well, in international arbitration, there's nothing like U.S. discovery that exists. However, a party can request certain documents from the other party and can ask the court to order that. It can only do so in a limited way. The request has to be narrow, it has to be specific, and it has to seek documents that appear to be material and that are reasonably believed to exist. So, and then it's up to the court to decide whether to order the production of documents. It's a hybrid. And I would say it's a hybrid that makes nobody happy. The participants who come from the common law side, I think, often still feel uneasy that a tribunal hasn't ordered enough exchange of information to be sure that the tribunal isn't missing something that's being withheld. And on the civil law side, on the other hand, there's a view that this discovery is expensive and intrusive and shouldn't take place. So what this leads me to is a reference to some rules called the Prague Rules on the efficient conduct of proceedings in international arbitration that were adopted by an ad hoc group in 2018. And I mention these because of the introductory materials associated with those rules, which make clear that those rules were prepared in reaction to practices that those who drafted the rules thought were too heavily influenced by common law traditions. So they developed a set of rules that they hoped would bring arbitral practice back towards a civil law line. And so the rules seek to promote a more active tribunal, moving towards a more inquisitorial approach of civil law courts rather than a tribunal that is receiving materials from the parties. The rules are designed to discourage any production of documents. The rules don't preclude production, but they try to discourage it. And in the hearing, the rules are designed to place the tribunal in the lead in examining witnesses, making any questioning by the party take a back seat. And lastly, the rules seek to discourage oral proceedings if suitable in a particular case. And that would typically be a case that's not terribly complicated. Well, that's interesting about this exercise is that it took place, and that it took place with a view towards trimming what was perceived as an excessive influence by the common law side. But what's also interesting is that all of the ideas that are in these rules, the ones I just summarized, are available under the rules that generally do apply, the International Bar Association rules. And as far as I know, these Prague rules themselves haven't actually been adopted. I still think they're interesting because they show in a concrete way something that I see every time I'm involved in any case, whether at the ICJ or in arbitration, which is that the differences that existed in 1899 are the same differences that exist now. This tension between the common law preferences and the civil law preferences come up all the time, and the Prague rules, I think, are a very good example of that. Now, just briefly, the way that decisions of arbitral tribunals are set out. Again, I can't give you a simple summary because they vary so much. These are three-person tribunals, and normally the drafting is in the hands of the presiding arbitrator. So there can be great variation. What I will say is that as in the ICJ, fortunately, the civil law structure does prevail in the sense that one sees a dispositive paragraph clearly separated from the reasoning. As to the style of drafting, I think it can safely be said that the style tends to align with the legal tradition from which the presiding arbitrator comes. I wish I could tell you that as to the substance and the reasoning, arbitral awards were shorter, as is often the case in the civil law tradition. But as I mentioned earlier, they do tend to be long, and the criticism about length that I've read and taken somewhat to heart, I think, is that they tend to spend quite a bit of time discussing legal points, and often there's some disappointment that the arbitrators don't set out in sufficient detail the reasons why they were persuaded or not persuaded on certain factual issues. Those parts of awards are sometimes more abbreviated. So I've tried to cover in a very snapshot way, I think, an overview of what happens in a national court on the civil law side or on the common law side, very much in a high-level way and overlooking, I'm sure, many nuances that each of you are familiar with. And then I've tried to explain to you why those have found their way into contemporary arbitration and adjudication, and what the state of play is in adjudication and arbitration. So now, what does that add up to? Quite clearly what we have is, in both cases, the ICJ and investor-state arbitration, we've got procedures and practices that draw from both traditions. A very well-respected former president of the International Court of Justice, Judge Manfred Laux, once said that therefore the ICJ had the best of all worlds. But I think you can see from this discussion, and if you think about it some more, that that might be true, but that these constant divergences in our perceptions and our preferences exist in respect of what is the best practice, and that we also always have to remember that what you have at home in your common law system or your civil law system is a system. It's coherent, it fits together. There are pieces that I didn't cover on the common law side or the civil law side that you really need to understand to round out how that works as a system. So you always have to worry a bit in these international systems about whether we're picking and choosing in a way that's missing some important elements. So what I wanted to leave you with today is not a detailed appreciation of all of the rules and all of the practices that apply, but really simply to hope that you will join me in being self-aware about your own instincts and tendencies, so that when you look at what the ICJ is doing, what an investment tribunal is doing, and you read about the procedures, you look at the way the judgment is realized, and you have an immediate reaction, or you're thinking about how to present a case before the court, and you're thinking, well, here's the right way to do it, ask yourself, am I coming up with this idea because of my legal tradition? Is there something in a different legal tradition that I should take into account to round out my influence? In other words, just as when you cross the street here in Japan, if you come from a state that drives on the right side, please look on both sides. Please look left and right. I invite you, when you're looking at these bodies, to look left and right and ask yourself in a self-critical and open-minded way, what's the best way to proceed, taking into account the diversity of influences on these bodies. I hope these remarks will help you as you move forward in your own careers, and I thank you very, very much for your interest in international law, the work that you do, and your interest in particular in international adjudication and arbitration. If there's time, I can see if there are questions. I don't know. 2 or 3 minutes, I'm told. Well, maybe, okay, well, let's see how things go. But if there are questions or comments, speak up. Sir?
Merci, Madame la Présidente. I think it was a very good expose of what civil and common law, but I'd like to, and I know it's difficult to place value judgment on either of the systems, but I'd like to understand from you, from a developing country's perspective perhaps, which tradition one must rely on, especially because I think in both the systems, as you explained, there are pros and cons, and of course one has to see what really suits in a particular case. And my second question from you would be that there is an attempt by some countries, especially the United Nations, to actually evolve treaty laws. For instance, in case of ISDS, and as you mentioned yourself, there are multiple arbitration systems, ICSID and the LCIA. So one example is, for instance, the Working Group 3 of UNCITRAL is trying to come up with a uniform law that could be adopted by all the states. And my third question, if you allow me, is that we've seen this problem, especially from my short stint at the Ministry of Foreign Affairs, this problem of double hatting. A lot of arbitrators become counsels, then they go back and become arbitrators towards the twilight of their career especially, and whatever laws that they evolved as counsels, precedents that they evolved as counsels, they would sometimes use them. A lot of publications have talked about that. So your views on that, please. Thank you, ma'am.
Is there anyone else who wants to ask a question or make a comment? Sir, I see we've kindly got someone who's going to, oh, you have a microphone. You're all ready. Please go ahead.
Yes, thank you for the presentation. My name is Ipian Amlilo from United Republic of Tanzania. First of all, I would like to appreciate the government of Japan for holding this seminar today. My question is it basing on the diversities you have taught us, is it the best idea to hire a leading counsel who has been practicing or representing the civil states in international courts and arbitration to lead the team of counsels in the common law state in those courts and arbitration? Thank you.
Thank you. Let me see if there's another person, and I'll try to respond to, I've taken notes, I'll try to respond. Is there anyone else? Gentleman in the back. Sorry, I think he needs a microphone, please.
Hi, my name is Shota Toda from Nagashima Tsunematsu. I am an international arbitration practitioner from Japan, and from that perspective, I have a quick question. It was a bit surprising for me. You mentioned the Prague rule as an alternative for the IBA guideline for the taking evidence. So personally, I've never seen the cases where the Prague rule were adapted in reality. But I'm very curious to know yourself or your fellow colleagues' impression about how the Prague rules will function in particular cases. Is there any particular problems in practice? I'd love to know. Thank you.
Thank you. Let me try to respond to the comments and questions that have been made, and then we may need to wrap up, or I'll see whether there's more time available. I'm not going to answer, I'm not going to address some of the bigger questions about arbitration that were raised, sir, with respect, because those are just beyond the scope of this lecture. You've got a lecture coming down that's specifically on investor-state arbitration. I was only trying to address these common law, civil law differences, so certainly you'll have an opportunity. I'm sure those kinds of points will be discussed when you get to that later in the week. But as to the points that are closer to this particular presentation, as to which tradition to associate oneself with, I think that that's really the key question to which my answer would be neither or both. In other words, the trick in terms of advocacy before the ICJ or investor-state tribunals when one is thinking about the civil law, common law divide is to be mindful of the fact that they are different and to ask oneself all along, what's a good idea here? It goes back to, it's just a variation of the general point that Mr. Reichler made. You're not trying to convince yourself, you're trying to convince the court or the arbitrators. If you're trying to convince yourself about appointment of experts, for example, that's not going to work because you have to try to understand how you think they might think. And to the gentleman from Tanzania, this is a point I'm always happy to talk about because whenever I have a chance to speak to persons who work for governments that don't have a lot of experience before the International Court of Justice, I try to say two things that sound a little bit inconsistent, but I mean them both. The first is that they shouldn't be afraid to put their own officials before the court, even if those officials are not experienced before the ICJ. And I emphasize that because I just want to say the ICJ works in English and French. We know that not everybody who appears before us will speak perfect English or French, and even if they do have excellent English, as you do, or English and French, they may not be expert on our court, but still, put them forward and let them appear. We want to hear what the state has to say. However, it's quite important for a state to be effective before the ICJ to have in its team expertise on the ICJ. Really, a state can't succeed without that, and that's partly because so much of what the ICJ has said, increasingly, especially on procedural issues, is in its cases, is in its jurisprudence. In fact, the very first case that I heard, which was a case that Mr. Reichler was involved in, this is Georgia-Russia jurisdiction. I dissented because the court took a position interpreting a procedural provision of a treaty in a way that I didn't think was correct. And I complained especially because I said I thought that it put too much of an onus on states to go and read the court's decisions to figure out what the court would do. So it's a fine line that has to be managed, and it does involve resource implications, but I very much admire states that are inexperienced but that put their own people forward. I do think that if a state comes from a particular legal tradition, it is especially worthwhile to make sure that the team includes somebody from the other legal tradition, someone who's experienced. In the court, it sometimes looks like what the teams are doing is just putting someone on the team who speaks French. So if it's a country that's Anglophone country, all the people who are showing up are maybe nationals of that country and maybe some Americans or British barristers and then a French person. But it's not really that. It's not really that the judges who are Francophone want to hear somebody speak in French. It's that the legal traditions are different and the team needs to have people within it who understand the tradition and need to be able to communicate with the court and help the other team members to communicate with the court in a way that will resonate with the judges regardless of where they come from. The Prague rules, yeah, so as I said, I didn't raise the Prague rules because I want to endorse them, and I'm not aware that they've ever been used, but I think they're interesting because they exist. I think they're interesting because they show in concrete ways the ways that investor-state arbitration proceedings are viewed and criticized from the civil law side. And even if the rules are never adopted, and I think very well very likely they won't be adopted, I think they indicate that this is a persistent problem, that the same kinds of issues, and you can go and read what these men in 1899 talked about. The same things that they debated then are still issues now. The civil law people, we don't want to be burdened by this procedure from the common law side, and the common law people saying, well, you can't possibly have an international court unless it has this or that. It's still there, it still exists, it's a very live issue, and that's why I wanted to call it to your attention. And now I'll call your attention to the fact that we need to wrap up so that the reception can start. And I apologize for running over. I thank all of you for your participation and for your questions, and I look forward to seeing you at the reception.
Thank you very much, Judge DONOGHUE, and for your very insightful and comprehensive lecture.